Good morning.
Morning.
Tuesday, August 4th, 2020, 19 miscellaneous 516, the Bevilacqua Company, Inc. versus Gloucester City Council, and we are live on YouTube.
Good morning, Council.
Good morning.
Morning, Your Honor.
Your Honor.
Welcome to our Zoom trial of this matter. We'll start off, as we always do, with swearing in the court reporter. Ms. Saint Amand, do you swear or affirm to honestly and accurately record the testimony in the matter now in hearing?
I do.
Okay. All right, let's proceed. First off, we had a view yesterday at the site at 116 East Main Street in Gloucester, and I want to know from council if there are any objections to the conduct of the view in any manner.
I have no objection, Your Honor.
No objections, Your Honor.
All right, thank you. And I believe we left for this morning, before we get started with the trial proper, a brief hearing on the motions in limine. Mr. Cohen has proposed the admission of two contested exhibits, one being the minutes of the city council hearing at which the applications for special permit were denied, and the other being the housing production plan prepared by the Metropolitan Area Planning Council. Let's just briefly, because I've read the papers, let me hear from Mr. Cohen on both of those.
All right, so the motion about the minutes first, Your Honor. The minutes, the decision of the council says right in it that the minutes are incorporated into this decision. The opposition that the council filed doesn't address that. They ignore it. There are many court decisions where minutes were considered. You know, minutes can be considered for certain purposes. You know, what somebody says at the hearing, at the public hearing, is not admissible for the truth of what they said. But you know, to determine, for example, the reasoning behind the council's decision, the minutes are admissible. And you know, I note in the Wendy's case that they cite, the minutes were admitted in that case. And then there's a footnote where they talk about a specific situation where I think it was the Board of Appeals of, I believe, Bevilacqua, was trying to say, you know, that one of the grounds that they were alleging for denying the special permit was, you know, it had to do with traffic. So they try to introduce, to prove that there was a traffic issue, the testimony of a couple of people who attended the public hearing, that there was a traffic issue, and that was deemed not admissible. The council misstates the law on this. You know, they cite, you know, which is maybe the leading case, the Kendrick case. You know, the Kendrick case.
I'm sorry, one second. This is my clerk in the courtroom is calling me about this. Yes. I'll have to talk to you. All right.
So in their memo, they cite the Kendrick case to say that the whole that minutes, when the courts admit minutes, the reason is that to set forth the date of the public hearing. But that's not what Kendrick says. You know, I'm just going to read it, the short paragraph here. Page 931 of the Kendrick case, it says, "We think the statutes just cited make public records such as those required to be kept by the board admissible to prove the specific matters which the statutes require expressly to be recorded. For example, the date of each meeting," you know, which they point out.
No, I get it. We always admit the decision, for instance, to show, you know,
Well,
fact of the decision.
But
Why don't you go on, Mr. Cohen, why don't you go on to the housing production plan, because I'm a little more shaky on why that would be admissible.
Okay, all right. Okay, Your Honor. particularly assuming if the minutes are admitted. You know, and I was going to point out what the Kendrick said, it basically is that the minutes can be admitted to show the reasons for the decision. In 48 section 15 requires that they give detailed reasons for the decision, but assuming that in the minutes, you know, here's a case where you have a decision that is kind of remarkable in the sense that it doesn't give it, I've read it many times, doesn't state any reasons for the decision.
Well, there's also case law that says that in a denial of a special permit, they're not required to give detailed reasons.
Yeah, well, maybe they're not required to give detailed reasons, but they're still required to give reasons. You know, they just can't give no reasons. They, you know, it would make a, it would negate chapter 48, section 15, which says that they have to give detailed reasons. Now, maybe it's more relaxed, but it doesn't mean that they can give no reasons.
Okay, so how does that make the housing production plan admissible?
Okay, so in the minutes, first of all, the counselors did speak and they gave some reasons for their decision. And one of the reasons that Councilor Gilman gave, she cited a portion of the housing production plan. And you know, that's one of the reasons that's in the minutes for their decision. And I think we're entitled to.
You're proposing it for that limited purpose?
Well, for that limited purpose. Also, I would submit that that this housing production plan by the MAPC, it was generated, it's required by a regulation of the Department of Housing. And
Yeah, but are you proposing that it should come in for all purposes to prove, say, the truth of the matter of the assertions in the plan about how much housing is needed in Gloucester?
Right. I think that would be proper to, not as a determinative factor, but I think it's relevant. I think it.
Wouldn't you need to have an expert witness on that issue? I mean.
Well, it's a plan that's been adopted by the, it was prepared for the city pursuant to a state regulation, and it was prepared by, you know, the MAPC was clearly an agent of the city in preparing it to comply with the state regulation, and it's very relevant. Councilor Holmgren.
It may be relevant, but Ms. Basu is telling me that it's hearsay.
Well, it's not hearsay if it was prepared by an agent of the city, and it seems to me that they were the city's agent in preparing it. If you look at it, you know, they're not questioning the authenticity of the document. They're not saying that it's not.
Oh, I know that's stipulated too. All right, I think I get the picture, Mr. Cohen. Let me hear from Ms. Basu and Mr. Nolan.
Yes, Your Honor. So with respect to the minutes, as the court has mentioned, you have our papers. And I would just call the court's attention to the standard of review for the denial of a special permit, and specifically the case of Davis versus Zoning Board of Chatham, in which the court stated that even if the board cites no particular reason for the denial, its action will be upheld if there is a rational basis for the denial, which exists and is supported by the record. And so
there's a lot of other case law that says that if the minutes or a transcript of the hearing discloses a pretext, for instance, then the transcript of the hearing or the minutes would then be admissible for that purpose.
That's correct, Your Honor. And in this case, there is no allegation of a pretext or of a improper reason or any type of bias by the board. And so it's the city's position that that case law is not what's involved in this case. And again, as the court has already stated, according to the Chiffon and the Maniaci case, denial does not require detailed findings. And if I could just, you know, the plaintiff's counsel has referenced the Kendrick case, which we cited in our opposition. And if I could as well read from the Kendrick case, it says, quote, the judge's use of the minutes was excessive in that he used them as substantive evidence that Kendrick or his attorney made before the board, the statements attributed to one or the other of them. And the cases that the plaintiff has cited, such as the Lobasar case, involved something like, the date of the hearing or the vote or something kind of a more, something that's required by open meeting law, that those kinds of facts can be admitted if they're in the minutes. However, we don't have a need for that in the case because those types of facts are included in the decision.
Okay, well, this council, the city council, took the unusual step of explicitly incorporating the minutes into its decision. And the decision is admissible, right? So how do I avoid putting the minutes in as part of the decision?
Well, the reference to the minutes being included is that there was a public hearing, that people testified, that the documents that were examined. It's sort of a record of what occurred, as I said, according to open meeting law in the hearing.
All right, well, on the minutes, just as a decision is admissible to show what the board did, and if it states the reasons why the board did it, where the city council, in this case is the special permit granting authority, has explicitly incorporated the minutes into its decision, made it part of the decision, then the minutes really have to come in to the same extent that the decision does. That doesn't mean that every hearsay statement in the minutes is admissible for the truth of the matter stated, but the minutes come in as part of the decision for that limited purpose. Now, let's cut to the quick on the housing production plan as well. In the minutes, which is now part of the decision, as stated by the city council, one of the city council members explained her reason for voting no, saying that, I think it was something like saying the housing production plan stated that East Gloucester was already developed a capacity and cited the housing production plan as the source of that information. And Mr. Cohn has cited specifically on page 60 of the housing production plan where that was discussed. And it doesn't quite say that. It does say that there are certain water and sewer possible capacity issues in the East Gloucester area. Why doesn't that come in for that limited purpose at least?
Well, again, according to the case law, that that there shouldn't be an analysis of specific city councilors and what their thoughts were. It's the decision as a whole that is admissible, and that what the standard is before this court is not to just show that there were reasons for it to be granted, that it could be granted.
I'm sorry.
All right, Ms. Sinema.
You just froze for me for about 10 seconds. I don't know if you can go back and repeat what you had said.
Okay, so this is something we expected might happen, and thank you for interrupting, Ms. Sinema.
Okay, sorry.
Thank you. So the case law is clear that there cannot be a review of specific counselors and their specific beliefs, but the decision must be taken as a whole by the city council. And also that the standard of review in this case and the issue before the court is not could the special permit have been granted, but is there no rational basis for denying the special permit? And so it's the city's position that that the housing production plan is not relevant for that reason.
Okay. Thank you both for your arguments on this issue. I do take slight, you stated, Ms. Basu, that the mental impressions, mental thoughts of the counselors in making their decision are not discoverable or admissible, and that's generally true. but there is an exception to that where their thoughts as revealed in, say, the hearing reveal that there may be a legally untenable basis for their decision. That's the Clear Channel case, Clear Channel versus Quincy, I think it is, a year or two ago. I think you need to have at least that part of the housing production plan in there to assess that issue. So the housing production plan will be admitted as an exhibit on an extremely limited basis, just to the extent that it is relevant to the statement made in the minutes by the counselor who explained her decision by reference to the housing production plan. I want to stress that I am not admitting the housing production plan for the truth of the matters generally stated therein. For instance, there's a long, the purpose of the housing production plan was to discuss Gloucester's housing needs over the 10-year period beginning 2010 through 2020. And I'm not accepting any of that. If Mr. Cohen wanted to prove housing needs in general in Gloucester as part of his case, he'd have to have an expert witness to do that, and putting the housing production plan in there for the truth of the matter stated there and generally would deprive him of the right to cross-examine, would deprive the city of the right to cross-examine on that issue. So the housing production plan will be admitted on that limited basis. Now, we've already admitted 3 additional exhibits by agreement. I saw this morning, exhibits 12, 13, and 14. Ms. St. Amand, I believe you've already marked those.
Yes.
Those are, 12 is a smaller scale excerpt from the zoning map showing the locus. Exhibit 13 is the full Gloucester zoning map, and Exhibit 14 is the permit plans that were submitted with the variance application last year and with the special permit application at stake in this case. Is that correct?
Yes, Your Honor.
Okay, I got that. So then the minutes will come in as Exhibit 15 for the limited purposes I've stated. And the housing production plan will be Exhibit 16.
Okay, thank you.
For the extremely limited purposes that I've stated. Okay, now I think we're up to openings, right? Mr. Cohen, do you wish to make a brief opening?
Yes, I do, Your Honor. My name is Arnold Cohen. I represent the plaintiff, the Bevilacqua Company, Inc. I'll refer it to sometimes to as Bevilacqua. I think as the court knows, this is an appeal under Section 40A, Section 17 from the denial of 4 special permits. The proposed project calls for 2 buildings, each with 4 apartment units in it on a lot that's approximately 3/4 acre in size at 116 East Main Street in Gloucester. There's an existing abandoned, I would suggest pretty unsightly former restaurant building on the property. I submit the evidence will show that the council decision is arbitrary, and to the extent that there are any grounds in their decision, that those grounds are untenable. The Chapter 48, Section 15, and I think we covered this, it requires that the decision clearly set forth the reasons for the decision. And I recognize there's a more relaxed standard because this was a decision denying the special permit, but the statute does not authorize a complete failure to set forth any reasons, which this decision does. It seems to me that with maybe in the final argument, I'll get to that. But the decision does note that there was a show of hands taken at the meeting. I would suggest that, there was a substantial majority of people who showed up at the meeting were against the decision. I know, that there's one case which I'll be able to cite later where the court observed that the sentiment at the public hearing influenced a decision. And I suggest that that's the reason why these special permits were denied. The matter was referred to a special committee of the city council. They voted 3-0 in favor of it. So I think that it's just evidence that this was arbitrary. Our two witnesses will be Paul Bevilacqua, who's the principal of the Bevilacqua Company, Inc., and Dan Ottenheimer, who's the engineer for the project. And there are several relevant provisions of the Gloucester zoning ordinance that apply. So I sometimes refer to that as the GZO, the Gloucester zoning ordinance. So under the GZO, in order to build a project with 8 dwelling units on this parcel, Bevilacqua needed to get a special permit under section 1.83 of the GZO. And the 1.83 states that it must be shown that the adverse effects of the project don't outweigh the benefits. So it's not a matter of having to prove that the benefits outweigh the adverse effects. The standard is whether the adverse effects outweigh the benefits. And 1.83 also states that the council shall consider 6 different factors. The ordinance uses the word shall, doesn't say may. However, there's nothing in the record that shows that the city council addressed any of these 6 factors. But Mr. Ottenheimer, when he testifies, he'll address these factors. That the community needs will be met by the project. One thing is that it'll provide an affordable unit, which is one of the criteria in 1.21 of the GZO. The unsightly abandoned restaurant will be raised. There'll be, replaced by an attractive project with landscaping, and his testimony will show that the design of the project will improve traffic flow, that there are adequate utilities and other services for the project, that the project will be consistent with neighborhood character, that the natural environment will be improved by the project, and that the project will increase the value of the property and thus generate increased tax revenue. The second special permit sought is to reduce the space between the 2 new buildings. Under section 3.2.2, footnote E of the GZO, as of right, the space between the buildings would need to be the sum of the heights of the 2 buildings, which comes to about 57 feet. Whereas the proposed project, that distance is 16.9 feet. So section E sets out standards for whether a special permit to reduce the space between the buildings will be allowed. And footnote E states that a special permit for reduced spacing can be granted on a finding that the reduced spacing is not detrimental because of view obstruction, overshadowing, service access, or visual crowding. The issue is whether any of these effects are caused by the reduced spacing. It's not whether the buildings themselves per se, it has to do with the spacing between the buildings. So
Which section is this, Mr. Cohen, again?
pardon me?
Which section is this?
This is 3.2.2 footnote E.
Okay, yeah.
Okay, so apparently the council takes the position that a neighbor's view, I think it's listed.
Objection.
Sustained. Let's just,
All right, so
this is not closing argument.
okay, all right. So the evidence will show that, I mean, there's no view. When you're talking about views, you're talking about views of the harbor in Gloucester. That's what I think people think of. The question is whether Pilot's Hill, which is the area behind the building, somebody's view of that is going to be blocked. And the evidence will assuming that that's the kind of view that's protected by that footnote E, submit that there's no evidence that anybody's view is going to be blocked of that hill, assuming that, you know, that's some kind of a view that's protected. Another factor under footnote E is whether the reduced spacing will cause detrimental overshadowing. The evidence will show that this will not be the case. Another criterion is whether there'll be any detriment to service access. We'll have evidence that there's service access and the reduced spacing will have no effect as far as service access goes. The last factor is whether the reduced spacing will result in a term they use, detrimental structural crowding. So there has to be there has to be some kind of a detrimental structural crowding. Now, none of these factors are discussed in the board's decision. They're not discussed in the minutes, but in any event, we submit there be no evidence of any of these, no substantial evidence of any of these detrimental factors, and that these detrimental factors don't exist. You know, as far as structural crowding, you know, our building is on a 3/4 acre lot. There's a lot of space behind the building. You know, there's a whole very wide area of open space before you get to any other properties. There's a 68-foot setback. The buildings are separated from the adjoining properties, the buildings on those. So we submit that the decision, if the decision is based on the footnote E of 3.22, it's arbitrary. Third and fourth special permits relate to section 3.2.2 and also footnote A of that section. Okay, and 3.22 covers the third and fourth special permits. It states that as of right to there has to be at least 5,000 square feet on the parcel per dwelling unit. Our parcel, you know, our plans call for about 3,800 square feet per dwelling unit. It also, as far as open space goes, it calls for 3,500 square feet of open space per dwelling unit. Our proposal calls for around, I believe it's around 1,600 square feet per open space per dwelling unit.
It was 1,700 and change. Yeah.
Okay. Now the criteria are set forth in footnote A for granting the special permits as far as those two factors. And what it says is that it has to be shown that the lesser square footage is in keeping with neighborhood character and structural density. That's the standard. Again, nothing in the decision or even in the minutes that address that. Agreed Exhibit 5 is a chart that was put together by the Gloucester Assessor's Office. And that, based on Exhibit 4, which are assessor's cards, it shows the square feet per dwelling unit and open space per dwelling unit of properties within a 300 square foot radius of 116 East Main Street. They also have, there's also an agreed Exhibit 7, which is a portion of the assessor's map that shows the distances between buildings within the 300-foot radius. Council's argument, well, these exhibits don't establish that our project is not in keeping with the neighborhood character or structural density. Look at that Exhibit 5. Most of the single family homes are on undersized lots. You know, 3.21 of the GZO calls for 10,000 minimum square feet for a parcel. You know, obviously all these lots are grandfathered, but most of them are less than 10,000. A lot of them are substantially less than 10,000. The lot area per dwelling unit shown on Exhibit 5. Our proposed project is not an outlier. It's consistent with what's in that area. And same goes for open space. And one thing about open space that I want to know is that open space is defined in Section 6 of the GZO. And one thing is that open space does not include driveways. And the open space on Exhibit 5 is calculated by the city council. And I don't think this is a dispute. In fact, the agreed statement of facts, when you look at that reference to the exhibits, there's a section in the pre-trial memorandum about the agreed exhibits. It notes that driveways were not included in determining the open space per unit. And you know, and the reason for this is that you can't determine what the square footage of the driveways are under the by looking at the assessor's cards. They don't give that data. So you know, and if you look, there's pictures on these Exhibit 4, the cards, and I think Your Honor would have seen it when he was, you know, in the neighborhood yesterday, that most of these properties do have driveways. So the open space per unit.
Objection.
What's the objection?
It's the Attorney Cohen is giving testimony of his opinion of the view.
Well, he stated that most of these properties have driveways. I can conclude that for myself from the view. So, all right, objection's overruled.
All right, so
let's try and keep this to the
okay, so I'll move on from that, Your Honor.
testimony expected to be presented.
Yeah, okay, you know, I'm getting there, Your Honor. A particular note as far as Exhibit 5 is that, you know, is that the multifamily dwellings in the 300-foot radius, most of them have less square feet per dwelling unit and less open space per dwelling unit than our proposed project. You know, like an example is 114 East Main Street, which is next door, the 5-unit apartment building. It has 5 dwelling units on 6,850 square foot lot. And you know, it has 1,370 square feet per dwelling unit of open space. So quoting from the Wendy's case, which states, page 387, that on review of the council's decision, the judge's role is to determine whether the reasons given in the council's decision, not reasons given at the hearing, but reasons given in their decision, not reasons given at the trial, Your Honor, had a substantial basis in fact, or were, on the contrary, mere pretext for arbitrary action, or veils for reasons not related to the purposes of the zoning law. I submit that based on that, the board's decision is arbitrary. You know, they don't give any reasons, but the 2 counselors gave reasons for the, well, there were 3 things that was said. One counselor said that basically we didn't prove that.
Objection.
This is argument, Mr. Cohen. This is really more appropriate.
All right, well, we'll make that argument at the end, Your Honor. But we submit that the evidence will show that the decision was arbitrary or based on untenable grounds, whether, and that for that reason, that given this, that the court should annul the council's decision and issue an order that the council allow the applications for special permits subject possibly to conditions relative to thereto. Thank you, Your Honor.
Thank you, Ms. Basu. Ms. Mullen, do you wish to make an opening at this time?
Yes, Your Honor. Good morning, Your Honor. Krishna Basu for the Gloucester City Council. The evidence in this case will show that the plaintiff's proposed project for 116 East Main Street in Gloucester is out of keeping with the neighborhood character. It will cause increased structural density, visual crowding, and view obstruction. It will have a negative impact on the city of Gloucester. These are all reasons that are stated in the Gloucester zoning ordinance to deny a special permit. Now, the court saw the site yesterday. Currently on the site is a building that housed a restaurant for many years. The plaintiff's proposed project, the application is contained in Agreed Exhibit 1 for a special permit, proposes that there be two structures built on the parcel of land, that they are only 16.9 feet apart instead of 57.2, that there will be 8 dwelling units on the parcel of land in the two buildings with 2 or 3 bedrooms, that the lot area per dwelling unit will be 3,809 instead of 5,000, and that the open space per dwelling unit will be 1,479 instead of 3,500. Now, the Gloucester zoning code, which plaintiff's counsel has referred to and which is before you as Exhibit 2, allows the special permit granting authority, the city council, to grant a special permit where the proposed use, quote, will not adversely affect the neighborhood, the zoning district, or the city to such an extent as to outweigh the beneficial effects of said use. And in the factors that the city council shall consider, it does include community needs, as the plaintiff's counsel has mentioned, but it also includes neighborhood character and includes the potential fiscal impact. Again, the Gloucester zoning code with reference to reducing the distance between buildings references that that is only permitted if it is not detrimental because of view obstruction or visual crowding. The Gloucester zoning code 3.2.2 also states that the minimum lot area per dwelling unit and the minimum open space per dwelling unit may be decreased by a special permit only where it is in keeping with neighborhood character and structural density. Now, the court will hear the testimony of Nancy Papos, who's the principal assessor for the city of Gloucester, and she will explain that she reviewed the records for all of the properties within 300 feet of 116 East Main Street. And all of those property record cards that Ms. Papos reviewed are contained in Exhibit 4. And using that data, she compiled that data into what is Exhibit 5, 7, and 9 in the agreed exhibits. And Exhibit 5, as plaintiff's counsel has mentioned, is a chart. And what that chart contains is the data from the assessor's field cards, Exhibit 4. And Ms. Papos will testify that what that data shows is that there are no parcels of land within 300 feet that have more than 5 dwelling units. One property has 5 units, one has 4, 2 have 3, and the rest of the properties are single and 2-family homes. Ms. Papos will also explain that the data that she reviewed and compiled shows that the majority of the properties within 300 feet have more lot area per dwelling unit than this proposal, and also have more open space per dwelling unit than this proposal. And Ms. Papos also will explain how she created Exhibit 9 using a tool to measure the approximate distance between structures within 300 feet of the parcel. And she compiled those distances in a chart, which is Exhibit 9, and she will testify that the majority of the structures that are within 300 feet have more, are more than 16.9 feet apart. Her testimony and the data that are exhibits in this case will prove that this proposal is not in keeping with the neighborhood character and structural density. Next, the city will present, and Your Honor will hear a testimony from Alberta Hill. Alberta Hill lives at 139 East Main Street, diagonally across the street from the property. And Ms. Hill will testify about how the views from East Main Street and from her residence of Pilot's Hill will be impacted if this proposal had been approved, would be approved. She will also testify regarding that there is not a restaurant in this neighborhood with outdoor space.
Sorry?
That there are no restaurants in this neighborhood that have outdoor space.
What's that got to do with anything?
Well, she would testify that that is something that is lacking in the neighborhood if the restaurant was eliminated and housing was there instead.
Well, the restaurant's been abandoned for years, so it's not a question of whether there's going to be a restaurant or housing, right?
That's correct, Your Honor. It has been abandoned.
Okay.
Finally, as I mentioned before, the Gloucester Zoning Code 1.8.3 mentions that the City Council may consider potential fiscal impact. Nancy Papos will testify, and Exhibit 10 shows the current taxes for the property, and it is primarily commercial currently. And the final witness for the city will be Richard Sapphire, who's the former superintendent for the Gloucester Public Schools. And he will testify that he anticipates from a building of this description of 8 dwelling units with 2 or 3 bedrooms, that he would project that there could be 6 additional students in the proposed development. And he will testify as to what the cost would be to the city of those increased students.
And this is relevant under the part of 1.8 that talks about fiscal impact?
Correct. This evidence will show that the potential fiscal impact of this proposed residential housing will be an additional cost to the city.
Do we have anything in the agreed exhibits? Because I saw the site plans that have been admitted, but you've both been referring to 2 and 3 bedroom units. How many of them are 2 bedroom and how many of them are 3 bedroom? Do we know?
I believe that is contained in the application in Exhibit 1, but I would have to review that, Your Honor.
Okay.
And I would anticipate that the plaintiff's testimony would also address that issue. But it is stated in Exhibit 1 that there will be 20 bedrooms.
Okay. I'm sorry to interrupt. Go ahead.
So in conclusion, Your Honor, the evidence in this case will show that the decision of the Gloucester City Council to deny the special permit should be affirmed. Pursuant to the zoning code, an application for a special permit will be denied if it is out of keeping with neighborhood character, will cause increased structural density, visual crowding, view obstruction, and have a negative fiscal impact on the city. This proposal is all of those things. It is out of keeping with neighborhood character. It will cause increased structural density, visual crowding, view obstruction, and have a negative fiscal impact on the city. Thank you.
Thank you very much, Ms. Basu. All right, Mr. Cohen. Well, first of all, let me just discuss our schedule a little bit. It's now 10:30. We usually will take a break around 11. I especially don't want to overtax Ms. St. Amand. It's a hard thing to be transcribing this continuously for as long as she does. So we will, at some point probably during your first witness's testimony, Mr. Cohen, take a break. Then we break for lunch about 1 o'clock till about 2 o'clock, and we go to about 4. Okay, Mr. Cohen, you may call your first witness.
Yes, Your Honor. I call Paul Bevilacqua.
All right, and Ms. Rosa will admit him from the virtual waiting room.
allow Mr. Bevilacqua in now.
I see something happening on my screen. Mr. Bevilacqua?
Your Honor, I could try to call him and find out where he is on
Well,
this.
I mean, there's a little icon on the screen. He needs to turn his camera on and his audio on. Mr. All right, I heard something. Mr. Bevilacqua, can
Yes.
you hear us?
Yes, I've got the audio working now.
All right, do you know how to turn on the video?
I thought it was on.
If you toggle over your screen on the lower left, there should be something, mine says stop video, but there you go. You're on now.
Got it?
Yes.
Okay,
you.
Ms. St. Amand, will you swear the witness, please?
Yes. Could you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, Mr. Bevilacqua, good morning.
Good morning.
I'll ask you a couple of things that I usually tell witnesses before they start their testimony, which is number one, keep your voice up, speak into the microphone, speak clearly. And because we're doing this virtually, I have to add a few other things. We issued a pretrial procedural order in this matter, which requires that witnesses such as yourself, number one, be alone in the room in which they're testifying. Are you alone in the room in which you're testifying?
Yes.
And you have to answer out loud with a yes. You can't nod your head. That's not sufficient. Thank you. You can't have any notes with you. You can't have anybody signaling to you in any way. And you can't conduct any private chats or communicate with anybody by text or in any other way while you're testifying. Can you be in compliance with all those rules?
Yes.
Okay. All right. The last thing I want to tell you is I want to be careful. This sometimes happens. I'm not saying it will happen now, but I want you to be careful not to speak over anybody's question. Don't start answering a question before they're completed asking it. Please don't argue with counsel for the other side if things get contentious, which they sometimes do. And if there is an objection, do not answer until I've ruled on the objection, okay?
Yes.
Okay, Mr. Cohen, you may proceed with your examination.
Could you state your full name and address?
Paul Bevilacqua, 34 West Street, Needham.
And what's your position with the Bevilacqua company?
President of the company.
Okay, and are you the sole officer and director of the company?
Yes.
And were you the person who founded the Bevilacqua company?
Yes.
And how long has the Bevilacqua company been in business?
1992.
All right, and what does the Bevilacqua company do?
Well, we specialize in residential construction, both single and multifamily.
And at some point, did you become interested in the property located at 116 East Main Street in Gloucester?
Yes.
And when was that?
Probably late 2017, I became aware it was on the market.
All right, and how did you become aware of it?
I believe an internet listing.
Okay, well, I understand you're not the owner of the property, is that correct?
That's correct.
And the owner of the property is a company called Sun, S-O-N, Inc.?
I believe it's Sun LLC.
Okay, thank you. And you have a purchase and sale agreement with Sun LLC?
Yes,
And is the closing date under the, strike that, is there a condition under the purchase and sale agreement that you obtain the special permits that we, that this case is about?
yes,
And has the purchase and sale agreement been extended?
it has, yes,
And that's because you're still trying to get these permits?
correct, yes.
All right, and are you paying as part of that extension with the owner? You pay, are you making monthly payments?
Objection.
Overruled.
Yes, we are.
Okay, and what's the amount of the monthly payments?
Approximately $3,800 per month,
And how long have you been making those payments?
approximately a year and a half.
Okay, and did you retain any professionals in order to assist you in obtaining the variances that you previously got and the special permits?
Yes, I did. A local attorney, Sal Frontiero, and local civil engineer, Dan Ottenheimer, as well as an architect based out of Ipswich. And his name is Bill Nolan of Savoy Nolan Architects.
And your original plan for the project, how many units did it involve?
Well, our original plan, when we first started internally before we showed it to anybody, we had one large structure. It was 20 plus units. And after a lot of debate, we pared it down to 12 units that were then pared down to 10, which was our first submittal to ZBA.
Okay, and how many buildings, when you, with the 10-unit project, how many buildings did you envision the project to consist of?
That also would have been 2.
Okay. Okay. At some point in one of the previous plans, is it the case that there were going to be 3 buildings?
We did have one rendition of 3 buildings that showed 10 units. Yes.
Okay. And so currently, what you have, when you got the variances and for the special permits, the plan is for 8 units, correct?
Correct.
And 4 units in each building, correct?
Correct.
And just to answer a question, am I correct that there'll be the proposal is for 4 3-bedrooms and 4 2-bedrooms?
Correct.
And am I correct that one of the units will be deed restricted as an affordable unit?
Objection.
Overruled. It's
That's correct.
already in, it's already in the application.
All right, now I want you to look at what's been marked as Exhibit 1, which is the application for the special permits.
Yes.
And if you look at, and is that the application that you submitted to the City of Gloucester City Council in order to obtain the special permits that are involved in this case?
Yes, it is.
Okay, and I'd like you to take a look at page 7 of Exhibit 1. The part, the part that's page 7 of attachment A.
What is attachment A to Exhibit 1? I just see.
Well, I think if you
the
turn,
application.
the pages are numbered, Your Honor, beginning at page 1. I think if you go past the signature page, then there is an attachment A, and what follows is
Oh, the first set of numbered pages, okay. You know, my set here goes from page 6 to page 8. I don't have a page 7.
Yeah, Your Honor.
Tell me what time.
I believe in the, if I may, Your Honor, I believe in the hard copy, somehow in the printed version, page 7 is near the back of the exhibit right before the abutters report. So it's 4 pages from the back. The electronic version is correct.
I'm not finding it. Let me try and open up my electronic version.
Yeah, I think it's correct on the electronic version, Your Honor.
Yeah, I have to find that. Okay. This is exhibit 1, right?
Right.
It's loading. All right, why don't you go ahead and I'll catch up to you on that, okay?
Okay, Mr. Bevilacqua, can you tell me what the picture, you see a picture on page 7?
Yes, I do.
Okay, can you tell us what that picture represents?
Yes, that's a superimposed front elevation of both of the structures onto a wide angle lens picture of the site, street view.
And is that picture intended to represent what the project will look like upon completion?
Correct, from street view.
And I have no further questions.
Good morning, Mr. Bevilacqua.
Good morning.
Person Abasu, and I represent the Gloucester City Council in this case. Now, the current structure that is at 116 East Main Street, that housed a restaurant for 25 years. Is that correct?
Objection. I don't know. I'm not sure how he knows that.
Well, if he doesn't, he can say he doesn't know.
Okay, all right.
It's my understanding that, yes, it was a restaurant. I don't know for how long.
Thank you, Your Honor. Excuse me. Thank you, Mr. Bevilacqua. If I could have you turn to Exhibit 1, which is a document. That is your application for a special permit, correct?
Yes, it is.
Okay. And on page 2 in the background, property history, it states that over the last 25 years that the property had been a restaurant.
Your Honor, the plaintiff will concede that that's what it says.
Yes.
Thank you. And is there a large paved area around the building currently?
Yes, there is.
Now, the proposal that you have for 116 East Main Street is to have 8 2- or 3-bedroom residences and 2 detached structures, correct?
Correct.
Okay. And you obtained relief from the zoning board to have the left setback of the property reduced from 34 feet to 7.6 feet. Is that correct?
Yes.
And you also received zoning relief for the right setback to be reduced from the required 34 feet to 15.2 feet. Is that correct?
Yes.
And the rear yard setback was going to be will be reduced from 34 feet to 4.3 feet. Is that correct?
Yes.
And in your application for a special permit, you have applied to reduce the space between the 2 buildings to 16.9 feet. Is that correct?
Yes, that's correct.
And you've also applied to reduce the lot area per dwelling unit to 3,809 square feet instead of 5,000. Is that correct?
Yes, that's correct.
And you have applied to reduce the open space per dwelling unit to 1,479 feet instead of 3,500 feet.
Yes.
Can you tell us what the current footprint is of the structure?
Of each structure?
No, the structure that is currently located at 116 East Main Street, which is an abandoned restaurant. Is it correct that the footprint of that structure is 4,404 square feet?
I don't know the footprint of that structure.
Okay. Could I have you, do you have a copy of what has been marked as Exhibit 14, which are the variance drawings for the property?
Let me check.
If not, I can show it to you.
Okay. Yeah, those are just submitted today, and I haven't sent those to Mr. Bevilacqua. You know, I wasn't intending to ask him any questions about it.
All right, Your Honor, may I share my screen with the witness, or?
You certainly may. I hope this works. Okay.
Me too. All right.
Now, have you been given sharing screen capabilities, Ms. Rosa?
Correct, Judge.
Okay, go ahead, Ms. Basu.
Mr. Bevilacqua, are you able to see Exhibit 14?
Yes, I am.
All right. Let's see. So looking at the first page of Exhibit 14, it states, oops, sorry, as I try to move it. The first page is described as existing conditions. Do you see that at the bottom?
Yes, I do.
And if you look, that's a picture of the current building on the site. Is that correct?
It appears that way, yes.
Okay. And the square in the middle represents the current structure, is that correct?
Yes, it appears that way.
Okay. And do you see, and maybe I have to enlarge it, that the existing building is 4,404 square feet?
Yes, I do see that.
Okay, thank you. Now, can you tell us what is the footprint of your proposed building, of the two proposed structures?
I don't have the footprint in front of me.
Okay. Is there a document that you could look at that would tell you what the proposed footprint is?
I've got a print that shows the structures without a footprint size.
Okay, so you don't know and don't have something that you could refer to that references the footprint of the two structures?
I do, but not quickly.
Okay. Is that contained in the variance plans?
I'm sorry, I didn't hear you.
For the application?
I didn't hear your original question.
Is that contained in the application?
It should be, and also I believe my civil engineer should have that information.
Okay, thank you. Mr. Bevilacqua, the current structure occupies 14.4% of the land. Is that correct?
I guess if you were to put that plan up and it indicated that by a surveyor, I wouldn't have any reason to doubt it.
Okay. I'd like to take another look and show the witness exhibit 14 again, if I may.
You may.
Can you see exhibit 14?
I can, yes.
And turning your attention to page 4 of exhibit 14, which is described as permit plans, there is a box.
Excuse me, is that page 5?
Yes, I believe it is page 5. Thank you. Do you see the box that says dimensional requirements?
I do. I can barely read it. I'm afraid my eyes aren't that great, but I can see the.
Let me try to enlarge it.
Okay, thank you.
Do you see in that box where it says, can't seem to.
I think that's pretty good right there.
Okay. Where it says maximum lot coverage % by structures, and it says existing conditions 14.5.
Yes, I do see that.
Okay. And then do you see that the proposed structure will occupy 26.9% of the land?
Proposed is where? Under that, I see building height.
Well, the problem is when I enlarge it too much, it cuts. Okay, now can you see that under proposed conditions that the proposed structure will occupy instead of 14.5% of the land, 26.9% of the land?
Is that what you have your cursor on now?
Yes.
I do see that now.
Okay, thank you very much.
You're welcome.
And can you tell us, Mr. Bevilacqua, what are the current dimensions of the current structure as far as the length, width, and height?
The current structure of the restaurant?
Yes.
I don't have that information in front of me.
Okay. Is the current height of the restaurant 21 feet?
If you showed me a stamped drawing that indicated it was, I have no reason to doubt that. I've never measured it.
And what are the dimensions of the proposed structure?
I had stated earlier that I don't have that in front of me,
Okay.
and my civil engineer would probably have that info.
And isn't it correct that the height of the proposed structure will be 29 feet?
I believe that's correct.
I don't have any further questions. Thank you, Mr. Bevilacqua.
Thank you.
Okay, any redirect, Mr. Cohn?
No, Your Honor.
Okay, it's almost 11 o'clock. We'll take a 15-minute break. Well, actually, it's 5 to 11 right now. We'll resume at 11:15. Okay, so I don't know exactly how we do this, but you can turn off your video and your audio and then come back on at 11:15, okay?
Thank you.
I could also put them in a waiting room if they would like.
Sure. You want to do it that way? All right.
It's up to-
Well,
Okay.
why don't you put them back in the waiting room and then you can bring them back in. All right. So Ms. Rosa will put you in the waiting room and we'll re-enter at 11:15.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.